Somalia's continental shelf. Kenya accepts that in 2007, the oil company Woodside drilled the Palumbo-1 deepwater well in Block L5 on Somalia's side of the equidistance line. Somalia did not consent to any of those testing or drilling activities. On the contrary, Somalia made repeated and emphatic protests against those activities as soon as it was aware of them and had the ability to object. By authorising and encouraging companies to undertake exploratory tests, Kenya accepted drilling in Somalia's continental shelf, the oil company, and by disregarding Somalia's objections to those activities, Kenya violated Somalia's rights. In addition to unlawfully interfering with Somalia's sovereign rights, Kenya's activities in the disputed area also violated its obligations under Articles 74.3 and 83 activities took place, and irrespective of the court's ultimate ruling about the location of the maritime boundary. Now, as the court well knows, Article 83.3 stipulates that pending agreement, the states concerned in assuming in cooperation shall make every effort to enter into provisional arrangements of a practical nature and, during this transitional period, not to jeopardise or hamper the reaching of the final agreement. Article 74.3, of course, contains materially identical provisions in respect of the exclusive economic zone. In Ghana, Côte d'Ivoire, the ITLOS Special Chamber stressed that the obligation not to jeopardise or hamper the reaching of a final agreement on delimitation is an obligation of conduct, one which requires the states concerned to act, and I quote, in a spirit of understanding and cooperation, end of quote, and I quote again, to make every effort, end of quote, to avoid impeding the reaching of a final agreement. And in light of this, the question for the court is therefore a simple one. Did Kenya make every effort to avoid jeopardising or hampering the reaching of a final agreement with Somalia on the delimitation of the maritime boundary? The answer to this question is plainly no. It is clear beyond argument that Kenya granted numerous licenses that both authorised and encouraged exploratory activities in maritime areas that Kenya were claimed by Somalia. And it is equally clear that in so doing, Kenya behaved in a manner that would be perceived by both the government and the population of Somalia as a deliberate attempt to deprive Somalia of its sovereign rights. This was self-evidently likely. Independent reports attest to the detrimental impact of Kenya's activities. One example suffices to illustrate the point. In its 2013 report to the Security Council, the United Nations Monitoring Group on Somalia highlighted the profoundly destabilising effect of Kenya's unilateral activities in the disputed area. The report explained that Kenya's decision to award in the contested area had led directly to a dispute between Somalia and the holder of several of those concessions. A dispute which could, and I quote, serve to create further animosity between the government of Somalia and Kenya and exacerbate tensions between Somalia and Kenya that have already been sharpened by political disagreements in respect of other territorial issues. Creating animosity and exacerbating tensions are inimical to the obligations enshrined in Articles 74.3 and 83.3 of UNCLOS. Kenya's principal response to Somalia's case has been to assert that the dispute with Somalia did not crystallise until 2014. As Somalia has already explained, That position is completely wrong and is contradicted extensively by the documentary record. As Professor Sands has explained, since as far back as the late 1970s, Kenya was aware that Somalia claimed an equidistant maritime boundary. Somalia never disavowed that position. Kenya's claim to the contrary is directly contradicted by its own statements, including at an earlier phase in these proceedings. In its preliminary objections, Kenya acknowledged that the dispute already existed at least half a decade before 2014. According to Kenya, it was only in 2009 that Somalia first disputed Kenya's 1979 EEZ boundary. And similarly, the Memorandum of Understanding, which the parties concluded in 2009, expressly referred to the existence of a maritime dispute and contained no fewer than 11 references to the dispute or disputed areas. Kenya's principal argument is thus fatally flawed. Kenya's other line of assert that no violation can occur where the activities in question are merely transitory in character. This argument also lacks merit. Article 77 of UNCLOS prohibits all unauthorised exploratory activities in Somalia's continental shelf. It draws no distinction between unauthorised activities of a permanent or transitory character. A temporary interference is still an interference, and particularly where it results, as here, in the permanent unauthorised acquisition of sensitive data concerning Somalia's maritime resources. Secondly, the case law cited by Kenya does not establish that Articles 74.3 and 83.3 can only be violated by activities that have permanent physical effects. Nor is there any mandate in the language of those articles for such an interpretation. What matters, as the Special Chamber recognised in Ghana, Côte d'Ivoire, is whether Kenya has made every effort to avoid jeopardising or hampering the reaching of a final agreement with Somalia. In the context of the existing dispute, Kenya's decisions to award oil concessions in maritime areas claimed by Somalia and to permit and encourage the carrying out of extensive exploratory tests in those areas plainly fell short of that exacting standard. And thirdly, and in any event, Kenya concedes that not all of the activities in question were transitory. On at least one occasion, a well was drilled on Somalia's side of the equidistance line. Thus, even on Kenya's approach to the law, the standard enshrined in Articles 74 and 83 was indisputably breached. Madam President, the consequences of Kenya's unlawful acts are straightforward. In accordance with international law, Kenya is obliged to cease its wrongful acts so as to respect Somalia's sovereignty and sovereign rights. In particular, it must cease to award any oil concessions north of the equidistance line, and it must annul such concessions as it has purported to grant. Although Somalia is entitled to substantial reparation from Kenya, in the spirit of amity and neighbourliness which Somalia hopes will characterise the parties' future relationship, Somalia does not pursue a claim for reparations for past wrongs. Instead, Somalia asks the court to do just three things. First, to affirm unambiguously the existence of Somalia's rights. Second, to recognise the violations of those rights that have occurred. And third, to order that Kenya shall cease its wrongful acts and take all necessary steps to terminate any measures that violate the sovereignty or sovereign rights of Somalia. Madam President, Somalia is one of the world's poorest countries. Following years of civil conflict and humanitarian disasters, Somalia's maritime resources are one of its few valuable assets. Unfortunately, they are also among its most vulnerable. Somalia has brought this case before the court in order to obtain vindication of its sovereign rights over those resources, which are critical to its future development and to the future security and prosperity of its people. As the preeminent guardian of the international legal order, Somalia looks to this court to ensure that its sovereign rights are effectively protected for the benefit of Somalia's people and in accordance with established principles of international law. Madam President, members of the court, thank you all very much for your kind attention. In accordance with our understanding of the statement at the start of this session, Madam President, this concludes today.
I thank Mr. Edward Craven, whose statement does bring to an end today's presentation of Somalia's oral arguments. I wish to recall, as mentioned at the opening of today's session, that the court yesterday received a letter from Kenya and a response from Somalia that present the possibility that the oral proceedings will continue beyond today. The matter is currently under consideration by the court. Once the court has taken a decision, the registrar will inform the parties as to the further conduct of the proceedings. For this reason, the reading by Somalia of its final submissions will be deferred to a later date. I shall now give the floor to Judge Benuna, who has a question for Somalia. Judge Benuna, you have the floor.
Je vous remercie, Madame la Présidente. Vous me permettrez de baisser mon masque exceptionnellement pour que je sois entendu. Je parle sous votre contrôle. Ma question s'adresse à la Somalie. Je souhaiterais que la délégation somalienne clarifie sa position au sujet de l'affirmation du Kenya dans son contre-mémoire, selon laquelle la borne numéro 29 à Dar es Salaam, qui représente le terminus de la frontière terrestre entre les deux parties, doit être reliée, je cite, dans une direction sud-est jusqu'à la limite des eaux territoriales, le long d'une ligne droite à angle droit de l'orientation générale de la côte à Dar es Salaam, laissant les îlots de Diua, d'Amasiaca en territoire italien. Fin de citation. Ceci conformément à la description générale de la frontière prévue dans l'accord de 1927, voire à ce sujet le contre-mémoire au paragraphe 33 et 35. Ma question est donc la suivante. Est-ce que, selon la Somalie, cet accord établit la ligne de délimitation, je parle de l'accord de 1927, est-ce que cet accord établit la ligne de délimitation de la mer territoriale entre les deux parties et, si tel est le cas, quelle serait la limite extérieure de cette ligne? Je vous remercie, Madame la Présidente.
I thank Judge Benuna. The written text of this question will be communicated to Somalia as soon as possible. Somalia may respond to the question in writing no later than 10 a.m. on 22 March 2021. The registrar will also convey the question and Somalia's reply to Kenya. Should Kenya wish to make any comment on Somalia's reply, in accordance with Article 72 of the Rules of Court, its comment must be submitted no later than 10 a.m. on 26 March 2021. This brings to a close today's session of these oral proceedings. The seating is adjourned.
preliminary